with a direction to the petitioner to pay a cost of rupees 10,000 to be deposited before the secretary, the District Legal Services Authority, Bongaigaon, on or before 24/6/2024. And on such payment of cost, petitioner was granted liberty to file written evidence on affidavit, all relevant documents to prove nationality. So it was made clear that if the petitioner does not appear before the said learned tribunal on the date fixed or on other dates fixed by the tribunal, the tribunal was granted liberty to dispose of the matter on the documents available on record. We take note of the fact that the order, the draft order on record dated 29/5/2024 is incomplete in certain aspects. And perhaps the matter was not brought to the notice of the bench. And therefore, the order passed on 29/5/2024 was not be signed by the bench. Next matter. Although the Technical for the FT matters has opposed the made in the writ petition and has also opposed the remand of the matter back to the learned tribunal in spite of consistent default on part of the petitioner to appear before the tribunal and take steps. Next one. We find force in the submissions of the learned standing counsel for the FT matters. However, as find a draft order dated 29/5/2024 on record, by which the then bench had passed the order to remand the matter back to the tribunal, payment of cost. As a under the facts unique to this case, not to be cited as a precedent, in order to maintain the judicial discipline, the court is inclined to allow this writ petition by remanding the matter back to the London member, Foreigners Tribunal, Bongaigaon number 2 at Abhayapuri, by setting aside the impugned ex parte opinion dated 19/5/2016, passed by Swain's page
36 of the order motion. 36, writ petition, page number 36.
page number 36. Next para. Next page, para 35 to 38. No, just click the next date of appearance. With the correction. Simon. Next para. The registry shall retain the draft order dated 29/5/2024, which is marked with letter X in the record. Rama, we are making the, just before that, it may be mentioned that pendency of the reference would not be a bar for the state authorities to take an appropriate action as they may so desire. In light of the background of the petitioner. We're making this an exception because we don't approve of this, but since there is already an order dictated, we go by that. We have made it clear there is not be a precedent.
Lordship, by which time I
Now,
have to?
24/10, you will have to pay the compensation, the amount of cost. 27/10 is the date for your appearance.
Observe, Lordship.
Item 2.
May I please, Lordship? Lordship, I filed an IA for withdrawal of the Wakalatnama on the instant case. But IA has not been registered yet, Lordship.
Okay. The Mr.
M. Islam.
Mr. M. Islam, counsel for the petitioner, submitted that he has filed an interrogatory application. Next matter stands adjourned. This matter. Because in IA today for withdrawing his Wakalatnama. Accordingly, the matter stands adjourned today. This rather than decide interrogatory application at next.
Item 3.
Item number 3,
Lordship, matter will fix for admission hearing, Lordship. Today I am not prepared, Lordship.
just a moment.
Okay.
Lordship, I think this one also was CAV Lordship, because in our records it shows CAV. Even
this one
item
Yearly.
4,
This was heard and reserved.
yes, even item 4 Lordship.
That's why.
I am not sure if there's a noting there like the previous file.
No, noting is not there, but
No.
we can understand what has happened.
This-
In this case, he has documents, but he has no link documents, and therefore the link documents not being there.
Additional affidavit
Uh,
was called for.
No, we don't know, but the traveler has discarded the evidence.
Yes.
Right?
Lordship will give a
Just
short
wanted
date
to-
because it's a 2019 matter, Lordship.
We just wanted to refresh our memory and refer, looked into it.
Disposal of receivable.
Both sides are represented on the pair made by and counsel for the petitioner. The matter stands down today. Next, nevertheless, as this is a old pending matter, the court is inclined to issue rule returnable forthwith without requiring any fresh step to be taken. Next para, this is the matter for hearing on 16/10/2025. So it is made clear that adjournment shall be granted on the next date of listing. We are giving it after puja, but no adjournment.
That's it.
Correct. Item 4.
Item 4 is
Gotcha.
also
That's okay.
will be the same thing.
Now, as travelers records are received,
Rule
issue rule as the records of the travel is received.
10th October this year, na?
Hmm.
16th. Hmm? Hmm. Oh. Ini cuma clear. Sampai gitu. Yes, Lordship. He will inform, he said,
It's not physically took his lordship after COVID lordship. I can inform lordship, I can. inform.
How all the respondents are present. So for ends of justice, the matter stands adjourned today.
Lordship may issue rule here also, Lordship.
Okay, then same order. Only the petition is absent on call. same date of hearing. The registry shall
I'm five nine. Between 5/20/20 or 3 to 10 equal goal Nikki.
Mr. Sharma, we are not saying it, please inform him. Lord, we are fixing it on the same date. Yes, right.
16/10 lordship. Look, be clear.
Item 5.
You know, it
Lordship,
is same, we are issuing rule and
It's
zero.
same thing, I think, that here also.
here the date would be different.
Yes, lordship.
Here, both sides are represented.
Hearing of which will be said, लिखी होगा.
This is a whole pending matter and the records of the tribunal is received. Issued rule returnable without requiring any steps to be taken. This is the matter for hearing on 23/10/2025.
23/10/2025.
Item 6.
My matter was also heard over.
Yes,
It was also hard earlier, Lord.
yes. You want to do it today or some other day? Some other day. Same order,
Same date of hearing, lordship.
23/10. You, sir,
7.
Amma 7/8/9. 7/8/9/9. My matter was also heard. No, lordship. I have finished. I left it. The matter was heard. I'm a
yes, item 7.
Lordship. Application is in bail, Lordship, and matter was heard earlier,
Yes,
so it may be fixed for hearing, Lordship. No, no. Will be hearing over it.
you want to do the hearing today or some other day?
As your Lordship's,
No, it depends on you. We
Lordship,
don't.
not today, because all our, these files have gone away for disposal, we'll have to search them out, lordship. I think 7, 8 and 7 and 8, lordship. 8. 8 or 9.
8 আমার
Ito ko yun. Magano'n mo. Oh, nag-click ko lang mo po siya. Iman ligda ako kayo. Sabi yan, 7 na makakapit.
The parent built it.
8. So, 18. File night.
Can you, since she's saying she doesn't have a file, can you make it a PDF and give it to her?
Yes, Lordship, I'm going to give her a copy of this file.
No, no, if it can be done in PDF, we have another reason to ask you. If it can be given to in PDF, you can also give a PDF copy to the court master. It saves us a lot of time to take this brief home and read.
Yes, I will keep.
Please scan for it. To at the court now.
Okay.
It will be a shortcut for us. We are more interested in that, you know, more interested in her copy, but we are interested in our copy.
Yeah.
PDF, give it to her and to the court master.
Yes, yes.
Both sides are visible. Same order. Based on 23, 10/24 for hearing. For these copies, I am not passing any order.
Yes, Lordship.
Okay.
Lordship hearing date is 23,
23/10.
You want to look?
23/10.
Okay.
Item 8.
Nine to our Naha friends in here. Here to one of them, no, we look on. 9, 11, 9.
Lordship, in this case,
Just now,
Yeah.
from technical side.
Yes, only that.
no,
Project which I expect.
nine. 23, 24. Which not 9 to the rise again. 9 to 24.
Now,
Well, of night.
I will guess. Okay, look, now. Respect what for a
Baksa. Baksa.
box. Yeah. It's a lot.
No,
319. Lordship, LCR also hasn't been called for in this matter.
item 8. Page 30. Page 38 is impugn order, Lordship. Annex 6. Lordship. Lordship, petitioner, it is a contested matter, Lordship. Gaupura, but one of the family.
To make your submissions, it gives an impression to us that you are prepared. But we'll adjourn the matter today because you don't have a good case. Today is an exception to the rule. Since this is, it was heard earlier, we'll take it up again on 23rd.
I said till that. Till that, Lordship.
Okay, we give you bail also.
Lordship, not to
Listen.
be deported. He's already outside from
It's an exception.
years.
Today is an exception.
I think she deserves it.
She
Lordship.
deserves it. She starts the submissions. We could have disposed it of because she has given documents which does not connect her to her projected parents. The two witnesses have come. These two witnesses could not link the petitioner to the projected parents. They don't know about the family of the parents. And therefore, although they appear as cousins, but the court discarded it because the family could not be linked together. So,
Lordship, we fix it up for hearing then in October.
yes,
23rd, Lordship. Meanwhile, we'll also
we are giving you
be
this because
ready.
in both the cases you are prepared. You are ready to argue.
We pray for a copy of this petition also, Lordship.
Okay, give her a copy.
PDF on the
PDF for delay.
Give PDF, it is easier for us
and the form of PDF. I will.
because in the bench I have a very weak memory. I would forget. Same order. Yeah, that's it. The learned counsel for the petitioner has paid for bail, which is proposed by the learned standing counsel for the FT matters. On the ground that the impugn opinion clearly reflects that the petitioner has not been able to connect him with his projected parents. Be that as it may, in view of the projection made, 10 days time to take bail of rupees 5,000 to the satisfaction of
Wait.
Superintendent of Police Border,
Baksa,
Baksa,
Lordship.
Lordship.
Baksa. List on. List on same day, 23/10.
23.
I'm highly obliged.
Item 9.
No. I just received that reply copy, affidavit reply, no manner, some time I require. I have not gone through reply. The next week, any day. It will be research.
We have to calculation.
Video.
Oh.
Video.
Wait, please, Lordship.
Please file affidavit. Reply is.
Prepare affidavit. Mintu Shoikia. I'm on behalf of M. Shoikia. We filed yesterday. We filed affidavit. 2 days complete. We file
Time
affidavit.
like.
Bandana Das, B Das.
October 17.
We won't keep you standing. Yes, please sit down.
Item 10.
So the students from this St. Joseph's Kohima. You may not find this bench very interesting because we are taking up foreigners tribunals matters, which is the foreigners tribunals are not there in
Cool.
Nagaland, so it may not be of much interest to you, but you will learn something about procedural parts if you are here. So that will benefit you for because we are primarily dealing with the trial matters. Subject matter may not be so interesting, but a bit of trial you can understand. Okay. Yes,
May I please, Lordship, impin order at page number 71, Lordship, and next 18, Lordship.
Well, within time, Lordship. Will any problem.
there is a Kohima Connect of this bench. Next week I am at Kohima. The week thereafter, my brother would be in Kohima. 2025. Okay.
You're Mr. Neil,
Lordship,
your name?
B. Borgohai, Lord.
B. Borgohai. Mr. B. Borgohai. Learned counsel appearing for the petitioner. Also heard learned counsel for the respondents. By preparing this writ petition under Article 226 of the Constitution of India, the opinion dated 22/2025, page 71, has been assailed, whereby the petitioner has been declared to be a foreigner of the post 1971 period. Issue notice, returnable 4 weeks. All the respondents are represented. Formal notice is dispensed with. However, extra copies within a period of 3 working days from today. Heard on the prayer for interim bail. Learned counsel for the respondents object to the same. But in view of the projection made in the writ petition, we are inclined to grant bail. Conditions can you do? Petitioners shall appear before the SP border Lakhimpur. All for the trial court records. List after 4 weeks.
Where is your DW1? Which page?
DW1, Lordship. Page number 65, type copy, Lordship.
55.
65, Lordship.
Page number?
Page number 65, Lordship, DW1.
No.
Or
Lordship, the name Lordship, I think there's a mistake at page 65. It's Dulaja Begum,
Let's have a
Dulaja
look.
Begum, but here it's Duleja Begum.
That's right.
Dr. Gopal Ali and Mohar Ali, husband.
Okay, license plate.
At page number 66, Lordship, signature Guleja Begum.
Page number
66,
56,
66,
66.
66, Lordship. Signed as Guleja
No,
Begum.
no.
Gulja Begum.
But this is the cross examination. Where is your evidence?
Lordship, evidence at page number 35, Lordship, and exactly
35.
35, Lordship.
Oh, this is mistake by the tribunal. She has signed as Guleja at page 66.
Yes,
But
Lordship.
the tribunal writes Guleja.
Uh,
That's the, okay. No, this is something I missed. I was missing and therefore.
The petitioner will appear within, when will
Yes,
clear?
I take bail.
Bail 10 days.
10 days, Lord. Much obliged, Lord.
Item 11.
Page 33, my lord.
53. We'll have to wait for some time for bail.
My lord.
But Mr. A.W. Aman, learned counsel for the petitioner, also learned counsel for the respondents. This petition under Article 226 of the Constitution of India has been preferred against the impugned opinion dated 31/3/2022, page 33. By which the petitioner has been declared to be a foreigner of the stream post 1971. Issue notice. Returnable in October, please. October. Returnable on so and so.
22nd October.
Since all the respondents are represented, formal steps are dispensed with. However, extra copies within a period of 3 days from today, for 3 working days. All for the TCR, both by email and usual. Prayer for bail will be considered on receipt of the PCR. However, in the meantime, if the petitioner is apprehended, she shall not be deported without further orders of this court. Petitioner shall cause production of this order, a certified copy of this order before the
SP Dhubri, Lordship.
SP.
Border Dhubri.
SP, there is no border in your page 4, paragraph 5th. It is not SP border, it's
Respondent 5 is incomplete.
only Superintendent of Police.
We'll make amendment.
SP border. Dhubri. SP border Dhubri. List on
22nd
October.
Man, सोनकली क्यों delay? Man, सोनकली
12.
Yeah, just give a brief address to the students.
Lordship.
Here we are dealing with citizenship issues. There are persons who are detected as foreigners who have come from the specified territory. Specified territory is present Bangladesh. So people who have come before 25/3/1971 and who have come after 25/3/1971 we are dealing with those persons who have come illegally. The tribunals give their opinion under the Foreigners Tribunals Order 1964. So that opinion is something which can be challenged only before the division bench of this court. And so all these opinions where the illegal migrants were declared to be so are putting up a challenge. So we are dealing with that issue. Okay. And you can guide them, Citizenship Act, Foreigners Act, and you can guide this. You can guide these students. We have three laws which are Citizenship Act, the Foreigners Act, as well as the Foreigners Tribunals Order 1964. Just give them a brief idea so that they will understand what they actually witnessed to do. Right. We don't want our students attending here perfunctorily so that they don't take away anything home. Correct? When they go out of this courtroom, they must understand that what they have witnessed. And since it's a learning process, you will kindly assist them and guide them. No, you can sit down.
It's not page 16, my lord. It's an expert opinion, my lord. Notice was not served. Para 2, my lord.
Same order, same party. The impugned opinion is at page 16. Opinion dated 8/9/2022.
No, my lord. Yes, sir.
SP Borpeta. SP Board of Borpeta.
Barpeta, my lord. Considering the expert, I may protected, my lord.
No
Not to
deportation.
be deported. Expired because had you given the report, if you had seen the report saying how the notice was served, I could have considered. We don't know. It was hung in the presence of the governor, maybe at your known residence or maybe not there. We must know how it was done.
I know. Grateful, my lord.
Item 14.
14 to. No, 14 to do it, no, sir.
Please, your lord. My lord. Page number 15, your lordship. Impong order. Page number 15 onward.
My lord. The petitioner did not receive notice, your lordship. Someone else was reached. Bail may be granted, your lordship.
Basic.
Yes, Lordship. Yes, Lordship.
My esteemed brothers read this in the meantime, paragraph 2.
Ma'am.
Lordship, it says, I have also just checked up the address of the proceeding in the opinion and the address given in the writ petition are same, Lordship. So maybe a notice was avoided.
Sticking
Yeah, no.
light post.
Yeah, the second one is that it was served on somebody else, it says, Lordship. Yeah, the procedure is not followed in total, Lordship. The light post must have. I don't know what to say, Lord. But even the conduct of the petitioner, Lordship, he very well knows that marked a D voter in the year, Lordship, 2000. The case was registered in 2000, but the references of IMDT reference, Lordship, of 2011, Lordship. Yes, Lordship.
My lord.
Yes, Lordship. Not,
But my lord, the petitioner is casting his vote. In the voter list, there is no mention about the D voter.
Lordship,
In
if
the
that is the matter,
1977.
Lordship may call for the records, Lordship, examine, because he's already been marked a D voter. How could he be casting his vote?
In the voter list, there is no mention regarding the D voter. My lord,
So either
In
there
the-
are two people by the same name, Lordship, or the voters list has been picked and taken as per convenience, Lordship.
my lord, and in the 1977 voter list, my lord, the petitioner name is appeared along with his father's name. At page 27, your lordship. And page 27, Janaddi Sheikh, his name is appeared in the 1951 voter list, your lordship. 1951 NRC. Akbar Ali, my lord, 257.
Lordship, how did the alliances come? He's in the voters list, he's Chakbar Ali, and here he writes Muhammad Chakbar Ali.
In the opinion, Muhammad Chakbar Ali is mentioned. In the opinion.
So if he's not the same person, then why is he before the court, Lordship? That's it.
My lord, one thing is interesting, my lord. The notice was received by one Shahwar Ali. And he is the brother of the petitioner, uncle's son, not own brother.
So some relation, Lordship.
Some relation.
Yeah.
My lord,
The brother means family, Lordship.
not own brother. My lord. My lord.
But since the first notice was served, that should have been taken into consideration and the order should have been passed. No, yes, Lordship, Lordship. It's very clearly mentioned in the law, Act Lordship, issuance of notice. And the father's name is also same. Not Lordship may fix a short date, I'll call for the records and then pass orders, Lordship. Maybe something is missing here. We do not have everything apart from the opinion. He's brought in documents because he had them. He knew about the proceeding, that is why now he's approaching this court after the ex parte order has been passed. And because now people are getting arrested and being deported. There is no answer to that, Lordship. No, and that is why I'm saying, Lordship, some things may not be here. So once the records come and it is from Dhubri, Lordship, we can get it straight. No, only one thing, Lordship, about the light post thing. Apart from that, or the petition is correct. Even this is not acceptable, saying he does not know about the proceeding. He was inquired, ERO went, he's been marked a D voter. नोटिस पाना के लिए दिखाऊं एक नहीं मुझे नोटिस पर उसकी भाई this brother, he's the younger brother. You don't know, please delay. Notice was received. Number 10, 11. Indian next, but it doesn't.
Ms. Verma,
Yes, Lordship.
if you come to page 8 of the petition, para 13A,
Yes, Lordship.
the grandfather's name is Powat Sheikh. Grandmother's name is Moijan. They
Yes,
had two sons, Amoddi Sheikh and Janaddi Sheikh.
yes,
Now, Amoddi Sheikh's son received the notice.
yes.
He is the son of Janaddi Sheikh. So, Amoddi Sheikh, because the father's name was there, that fellow received the notice and he went to the tribunal, said that I am not that man.
Yes.
I am son of, I am so and so, although I am son of Amoddi.
Ahmad.
And there is no proceeding. Therefore, the fresh notice, which again quote says Amoddi Sheikh, son of Amoddi Sheikh,
It had to be Janaddi.
Chagar, son of Amoddi. There is no son, there is no Chagar, son of Amoddi. So he pastes on the light post.
Right.
So the correct description was not there. Notice not served properly. So we call for the records, see whether that has happened.
Yes, Lordship.
And you have come June 24.
My lord,
Just
he
missed
has
the
come to know
button.
later on, my lord.
Ah?
He come to know later on about the income order.
Your family stays very apart all the country.
I have only one submission, Lordship. Now, just when these matters had started, when people were started to get arrested, I had mentioned before this court. Now we will get lot of ex parte orders coming before the court because people have been sitting quiet or they have never attended, they've accepted notice not. So this is one of those matters, Lordship.
In the earlier matter also,
Yes,
because he
Lordship.
could not produce the notice, he
Yes.
did not give him a relief. But here the order reflects that there is a mistake in the order itself.
Yes, there is some,
Can we turn our eyes away on that?
no, Lordship.
Had this sentence not been there in the order, it would
Yes.
have been the usual order. But
No.
now that
Now Lordship has pointed out something which even I had not gone through because this file was not with us. I just collected it. Most of the time, something good is happening and the files are not with us.
that is what we tried to do when we were handling another department.
Yes,
What I had done was every filing, they had to give a PDF at one of your email ID.
yes,
Or at the computer located there, you just take a PDF copy.
yes, Lord.
Always accessible on any of the tabs or any of the mobiles.
We'll have to.
You'll
do
always
that.
have that access. If you
Yes,
get connected with the Gmail account, you have an access to that. It is there in the drive, not on a computer.
okay.
Everybody is using an iPad almost.
Yes,
That
Lord.
iCloud is always there. It is
Yes,
accessible
yes.
by most of the people. You don't have to look for files. That is why we are now trying to take PDFs. While receiving notice, if you take that PDF, every problem is solved.
Foldable आएगा.
No, there will be no loss of document.
Documents, Lordship.
Some paper safe.
They don't bring Lordship. I have seen that. They just, even in the courts, Lordship, everything is on PDF. right in front of you, and the judges are also functioning like
One
that.
of the biggest departments, the education department, most of us who were then doing the matters, we used to share our files only on the
PDF.
iPad. We used to have everything. We just need to send it via WhatsApp and it's openable. It's
Hmm.
readable on the iPad. Anyone who wants to instructions, read petitions, affidavits, everything was coming on.
Hmm.
During the court hours, the department used to send us their copy.
Hmm.
We'd argue on them. If you take PDFs of every now fresh matter coming up,
It helps.
they
lot.
have to make a photocopy. All they need to do is put a pen drive into that photocopy machine.
Hmm.
There's a PDF ready. There's no extra charge. There's no extra time limit.
So, we'll have to
Start taking
insist.
PDFs, at least at your end.
We need to lordship.
Then disposed files issue does not come in because it is always there.
Hmm. Unimaginable files are there in the chamber. Too difficult to hunt it out now.
Start taking
PDFs.
that is the only way now with the number of cases which are now will now flow in our.
The lordship may.
Yeah.
Text one may be given, my lord.
Heard Mr. A. Rahman. Counsel appearing for the petitioner also heard the respondents. In this writ petition under Article 226 of the Constitution of India, the petitioner has essayed the opinion dated 27/6/2024, page 15. Issue notice returnable 22nd of October, didn't it? 22nd of October. Since the respondents are represented, formal steps are dispensed with. However, extra copies within a period of 3 working days. Call for the TCR also by email. Prayer for bail will be considered on the next returnable date. However, if in the meantime, the petitioner is apprehended, he shall not be deported without further orders of this court. Released on 22nd of October 2022. Something happens in between.
Yes, lordship.
With that statement, do you want us to express in the order that the Home Department shall look into this order and
Yes.
the service is not made in accordance with law? Therefore,
Lordship can give because
advisory should be
it will
sent.
be taken up when we have the orientation course also. Lordship may put it up.
Okay,
Mr. Majumdar will take care of it there, lordship.
okay. You're referring to my brother? No.
No, 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 no. Lordship knows which
No, we don't
I'm
know.
talking about.
No, no. We don't.
I am extremely sorry, lordship. Or maybe that is why lordship was a bit startled. No, no.
Add the one line. Uh, we are surprised to note from paragraph 2 of the impugned opinion dated 27/6/2024 that the learned tribunal had recorded due satisfaction of service of notice, although the notice was pasted in the lamppost of the village. Full stop. Therefore, it appears that small issues, even with regard to the manner of service of notice, has is required to be the memory of the tribunal is required to be revived to have a refresher training for all the members and the process servers of the foreigners tribunals so as to ensure that notices are duly served in accordance with law or not at all. Next para. The learned standing council shall, for the FT matter, shall transmit a downloaded copy of this order to the competent authorities in the home and political within bracket B, bracket close department to bring the order to the notice of the said authorities. Next para. We request the authorities in the home and political within bracket B, bracket close department to circulate the copy of this order to all the foreigners tribunal pending refresher training program in near future. After distance.
Your Lordship.
Item 15.
May I please, Your Honor? Lordship, kindly pass over the matter for time being.
The impugned opinion is of 30/10/2021, Lordship. 21 years. Sixty lot. 23, maybe this is a review.
May I please, Your Lordship? Sorry, kindly pass over the matter for the time being, ma'am.
Yes, yes, Tahir Ali, rating 33. Yes, 37 of Aswata. 37 of Aswata. Hmm. 23. It should be 23.
Yes, Lordship. Next week. Next week.
You have to amend the petition or this is the date, but you are not given a different date. I to petition.
Your Lordship. Lordship, kindly fix a date.
When can I first?
Okay. It's my next one.
Ganun, subukan niya pa. Hindi ako ginagawa.
Item 16.
Right, please, your lordship. My lord, contested case, my lord, page 130, my lord. 130. Old case, my lord.
Person is the same even if the case is old.
Appearing for the petitioner also heard counsel for the respondents. The opinion dated 23/6/2025 passed by page 130 cover has been assailed in this writ petition under Article 226 of the Constitution of India. Issue notice, returnable 4 weeks. Since all the respondents are represented, formal steps dispensed with. Extra copies within 3 working days. Heard on the prayer for interim bail. When a counsel for the respondents object to the same, in view of the projection made in the writ petition, we are inclined to grant bail. The terms and conditions, petitioner shall appear before the Superintendent of Police, Border, Golaghat. List after 4 weeks with the trial court records.
Obliged.
Supplementary item number 50.
Worship, in this case, on the previous occasion, there was a deliberation as to whether the petitioner can approach CA authorities for registering her name. That was
Yes.
not recorded in the order, perhaps. I was advised.
Yes, yes, I remember.
Yes, Your Lordship, I have a
Lordship, not now, some more time is required.
She approached the Canada by mistake, but she has to go to the court. Sometime.
Yeah, you can also tell the court this, that he's approached.
Is the impugned order?
Lordship, it was an ex parte order.
When,
It's,
not the miscase.
thereafter, there was a miscase for setting.
Where is the original order?
Original order is at
Yes, 23.
23.
Ex parte. Why were you absent?
Lordship, she is a patient of schizophrenia. Initially, she appeared for 1 day, thereafter, she disappeared. And thereafter, her son preferred an IA, a miscase,
Hmm.
stating all the grounds and submitting all the documents.
Hmm.
And that was dismissed by the order at page 31. All he paid for is an opportunity to produce the documents because he had produced the certified photocopies only. In fact, there is one document, the migration certificate, which contains the name of the proceedee herself of 1970.
No, that she's suffering from some illness where, which documents can you?
Lordship, the petition is at page annexure 4, it's at page 26, Your Lordship. Para 4, 5, para 4 is the delay, explanation of the delay. Para 5,
No, that
Onward.
she's actually suffering from some schizophrenia. Where do we find it?
para 5, Your Lordship, in page 27.
Any document to show?
Documents, I have annexed some of the documents because it is medical documents. I did not annex all.
Page 22 is of 2019.
Lordship,
Order is of 16.
2016.
But this 22 doesn't help you anyway. Doesn't help you.
Lordship, in fact, there were other documents. I did not have had the original because so I could not annex all those. I have to certify those documents as well.
Now, what did you place before the tribunal? Which document?
Lordship, before the tribunal,
In your miscase?
in page 28, Your Lordship, para 7, all the supporting documents to prove the citizenship, Your Lordship, including the migration certificate and everything.
This was filed by the son.
By the
That is what I'm asking you. Your son must have, the son must have said before the tribunal that the mother is not capable of.
Lordship. There was a power of attorney as well, Your Lordship. It is at page 20.
Schizophrenic person you are saying that cannot
But
defend herself in the court, but.
I understand. That's why I'm not
Don't
annexed.
go for those.
That's why I'm not annexed.
That will not, that is not taking you anywhere. What I'm asking you is.
Medical documents.
Did you submit any medical documents before the tribunal to show that the proceedee was suffering from a mental disease which disabled her from defending herself properly?
Lordship, with the migration certificate, now they can apply for in the Amendment Act, Lordship.
Hmm.
If they have a migration certificate, they do not need any other documents. You can go and apply for the citizenship under the CAR, Lordship.
That's what
Amendment Act.
was
Did you
deliberated.
apply?
That was deliberated on the previous occasion, Your Lordship. And I have advised them, but they have approached the FRRO by mistake. So if some time is given, they will approach the correct authority. Only one thing, your lordship, just my prayer that they will approach the TA authorities would help because it's a pending case. The authorities may not accept their application.
Lordship, the thing is,
No, what happens
Let-
is not your concern, you must apply.
Yes, your lordship, I have advised them. So just 10 days time would be.
She's on bail.
Yes, sir.
She's on bail.
She's on-
Go in, you go and apply.
Okay.
They do not accept, they accept something.
I
Come
can,
back.
I can come back.
Tell us.
I can come back.
Lordship can even observe that pendency of this writ petition may not.
Already
Let
she has
me-
been declared to be a foreigner. It's already been declared. There might be one,
No, we are.
I don't know
we are
how people
also waiting
understand.
for-
So
We are also waiting for some clear instructions on, especially for this. And there has been some deliberation over the last few days, last week, in fact, after the Home Minister.
how
was
much
there.
time?
Lordship, 2 weeks, 3 weeks, Lordship. She may go and approach. If she has any difficulty, they can get back to us and then we'll work it out, Lordship. बेटा, अपने department को कोई नहीं। Yes, please.
Heard, both parties are represented. On the joint prayer of both the parties, let this matter be listed. Puja pisot data dia. Puja. Ito. 15th of Iman also. 17th October 2025.
October, Lordship.
17th October 2025.
Okay.
We have simply said joint prayer of both the parties, you work it. Hmm. Hmm. What is the complaint? That one. Hmm. Okay. Religion. Ini coba ini lipat.
Are you aware whether the petitioner has any landed property?
Lordship, at present, I am not aware, Your Lordship.
You know, you see,
Lordship.
there is nothing on record by virtue of which we can assure to ourselves that the disease which the petitioner is having would make her a person of unsound mind or a lunatic. We can't arrive at there's no material for us to presume that. That's
Lordship,
number one.
as regards to the question posed by Lordship, as
No,
regards
but,
whether,
I have a different way of putting it. Same question with a different angle. Now, once you take a plea that a person is of unsound mind, please tell us how would you handle a litigation?
by a guardian appointed by the court, most probably.
Correct. So that is missing, number one. Number two, in this case, the writ petition, the affidavit is sworn by the petitioner.
Right.
And when she has come here and signed,
Lordship, I have met her in person, Your Lordship. She appeared to be normal at that point of time. But recently, when I've communicated with the son as regards to this application,
no, some communication with some, you see, if you ask about me to any member of the bar, 80% will say that he is gone crack. 80% will say that only. But would it make anyone a person of unsound mind? No.
No.
Public opinion will not make anybody a person of unsound mind. Therefore, you have Evidence Act with you? No. Section 118
yes, Lordship.
of the Evidence Act. There's an explanation to it. Who may testify?
to the explanation, your lordship,
Any
unless he is
person, start
prevented.
with any person. So any person would include even a
Lunatic.
uh, uh, otherwise disabled person. Now explanation. Please read loudly, so I'll refresh my memory.
A lunatic is explanation part only. A lunatic is not incompetent to testify unless he is prevented by his lunacy from understanding the questions put to him and giving rational answers to them.
So therefore, this is the second part. The third part is, you say that you are an attorney. Before the tribunal, you did not produce the power of attorney.
It was produced, your lordship. It was produced. It
Produced.
must be there in the records, your lordship. And the medical documents were also produced as asked by lordship. Annexure A series of 7 sheets were the medical documents, your lordship, along with the ex parte vacating petition. And the power of attorney was, a photostat copy was produced, annexure C. That is not annexed here, your lordship.
Okay, so it's available here.
The records
me-
are here.
Now, this would again be interesting. We have a copy here, we found it. This is a special power of attorney done before a notary.
Noted.
And this special power of attorney was executed on 20 June 2019. 20 June 2019 would make it prior to filing of this writ petition,
Your lordship.
correct? So on the day she is appointing an attorney, she is not lunatic.
Lordship, what I have been
Therefore, you,
told-
you can't say, pick and choose that on first she was lunatic, second she was not, third she was again a lunatic, fourth she was not.
that is not the submission. However, what I have been told is that there are lucid intervals, your lordship. But that cannot be proved here, your lordship.
But then you are,
The lunacy as a
on-
ground,
but on merit, we'll have to discard your writ petition then. You take an inconsistent stand. The doctor's certificate doesn't carry any meaning. The doctor merely says that she was treated elsewhere. Now she is under my treatment.
the certificate that is annexed with the writ petition. And there are other documents.
That is under the medical guidelines, it's a misconduct. Are you aware of it? Have you checked the medical medical ethics? The in the requirements of the doctors to do, first requirement is that a doctor must have a history before examining a patient. A non-recording of a history by a doctor is a misconduct. So a doctor, you see, we are examining it as a medical legal document. As a medical legal document, we examine also the correctness of the certificate. Merely a doctor says that the person is not, she's lunatic. Will have different different consequences. Have you read the Mental Healthcare Act? Section 2 has provisions by virtue of which the definition is defined. Then again, 56, section 56 or something. Just give me Mental Healthcare Act. There is a state authority who is under the Mental Healthcare Act competent to declare anybody as a person in need of mental treatment. And this lunacy can only be declared for the purpose of treatment, not for anything else under the Act. Here you see section 3(2). That's right. That's- okay. T2,
Your Lordship.
the authority shall only make the declaration for the purpose of treatment, nothing else.
Your Lordship.
And in your case, what has happened? You've seen the doctor's certificate. Your doctor's certificate says that the attendant tells him that the patient is a mental patient and he accepts it. If he is a doctor treating, knowing the history of 18 years of illness and asks for continuation of medication, can he say, is it open for him to say that I have heard it from the attendant that she is medically ill?
He had to examine it himself, Your Lordship.
Then he has not done his job. So in fact, the maintenance rate petition would now be questioned. And after that, you have state authorities. Nobody can do it. Because after this declaration, she comes to the notary and signs the special power attorney. That means you know when she can sign, and therefore we ask that question, whether your mother has properties. Because then the intention of the son would be different. I start thinking with the negative, excuse me for that.
Yeah, that's required sometimes, Your Lordship.
So therefore, why would a son declare mother to be a mentally unsound person? We don't get it. We are finding a big gap here. To take a call, we leave it to you. Next time this issue will come, if I remember it. Okay. Yes.
Senior Please, Your Lordship, the ex parte order, Lordship, the notice was hanging, Lordship. Hanging.
Because she left the locality, Lordship. She changed her residence without informing the authorities. At page 14, Lordship. It's a 2018 case, Lordship, but the IMDT reference is of 98. Page 14, paragraph 2, notice was issued upon the opposite party. As per the report of the process server, the notice could not be served as the OP was not found in the locality. In support of the report of the process server, the ward commissioner, Borpeta Road Municipal Board issued a certificate that OP was not found. Thereafter, the notice was hanged in the last residence of the OP. Thus, the notice is deemed to be served. The tribunal fixed the case on so and so, but she never appeared, Lordship. And now cannot take the plea that we were not aware of the proceeding, Lordship. 2018 Borpeta matter. Last one was also Borpeta, no?
Lordship, I filed
Just a moment.
Eighteen or opinion 25 of accuracy because not delay to explain করা নাই delay to আপনি explain করেছেন কিন্তু প্যারাগ্রাফ
তার হাজবেন্ড ঢোকাইছে ফাইন্যান্সিয়াল হার্ডশিপ তারা তো আচ্ছা injunctive injunctive line the lordship file affidavit lordship page 49 lordship. The earlier lordship after extension, 2 lordship. The 2 is the 9 lordship. After extension, the 2 is the 9 lordship. Yes, lordship. 2 and the 9 the same address, lordship. 2 and the 9 word number, lordship. After extension, the number has changed, lordship. The affidavit, lordship, 49 lordship, paragraph 2 lordship.
আপনার সাইটের নাম আছে আপনি সাইটের নামও ডকুমেন্টস লাগাইছে আপনার নাম সিস্টেম কিতনে আছে হাজবেন্ডের লগত
89 নাম তো ভুল দেখা হয়েছে Now 89 এ বলছে।
89 ও তো কোথা আছে এক্সট্রা একটু কোথা আছে এটা ইয়াতে কোথা আছে দাদা
কি
আপনার 89 এর নাম তো
45 এ আছে 45 পেজ।
এটা কি 89 এটা 89 কোথা থাকে
এটা উদ্দিনটো
একটু আপনার নাম হবে না একটু তো মতে আমি জেরিন
জেরিনা
উদ্দিন
এইটো টাইটেল সেইটো
Wait.
রংলি লিখিছে এইটো।
হুম
প্রবলেম
loudly lordship হুম
সম্মানটুকু বিনীত নিবেদন এই যে ওয়ার্ড নাম্বার লৈ গৈ তাতেই আৰু নগৰ ৱাৰ্ডৰ শিয়াল মানুহৰ লগত আলোচনা কৰা তেওঁ ৱাৰ্ডৰ মানুহ নাপায় সেয়েহে 9 নম্বৰ ৱাৰ্ডৰ কমিশনাৰৰ লগত মানুহজনীৰ কথা আলোচনা পায় তেওঁ ৱাৰ্ড কমিশনাৰে চিনি নাপায় আৰু 9 নম্বৰ ৱাৰ্ডৰ তেওঁৰ ঘৰ মাটি থকা দেখা নাযায় গতিকে জাননীখন জাৰি কৰিব নোৱাৰি 9 ৱাৰ্ডৰ কমিশনাৰৰ জবাব এখন বিচাৰি প্ৰমাণপত্ৰ লৈ জাননীৰ লগত ৰাতি জাননীখন মহামান্য আদালতলৈ প্ৰেৰণ কৰা হ'ল মোটামতে আমি UPRD ৱাৰ্ড নাম্বাৰ 9 গৈ জাননীত মানুহজনীৰ ভিতৰত তেওঁ আমি বৰ্তমান দেখুওৱা নাই সেয়েহে 9 ৱাৰ্ডৰ কমিশনাৰৰ প্ৰথম কপি পঢ়ি লৈ দ্বিতীয় কপি বিপৰীত পক্ষৰ সেই বাসস্থানত আৰি প্ৰথম কপি মহামান্য আদালতলৈ প্ৰেৰণ কৰা হ'ল
what number
Father's Lordship.
Then her is 40. Eight.
Father's model.
That is the parents.
Oh, better.
No problem.
Lordship. President. Duke.
Nine, what nine lordship? Which is.
Father, father resides in the Mongol town. Lordship. Lordship. Lordship.
When nine both, affidavit, additional affidavit filed by. Yes. And reference was made when she was with her father, not when she was married. It's a 98 reference, not when she's 60 years old today. So that means she was born sometime in 66 or 65. Yeah, no, not if they लेकिन directors, we will get it done from the SP office. Yes. We can get it done from the SP office. Yes, yes. Nowadays, it is very easy to put the location in the GPS. Next, Borpita lottery, we can get it. Please take that. Let's take that. Constable border. TNB. Constable border. Sumit Vikram. Sikta. SIKDAR. No, there are two. One is Sashi Mohan Talukdar. TNBU. Okay, just send it. Fifteenth of, 15th of September. Lord, can we have a photocopy of that? Yes. Fifteenth.
Can it be 19? Wow. Wow. Yes. 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 89. It- 45. 45.
Parents one.
Parents. Lord. Okay, 45.
45.
Other in.
When I first checked that and I asked doctor, because doctor, there are 4 LICs to her name. Three are in the petition and one is here with Lordship just showed Jerina Udin. There has no explanation to that, just wrongly, can have to the copy by. Yes, Lordship.
What is your submission? What is wrong in this opinion?
On the earlier occasion, originally the proceeding has already filed her written statement, given her evidence, everything given. Why was it remanded back?
Page 90.
Why? No.
No. Page 90. Page 90.
Para 6,
90.
page 9.
Para 6, page 90. 90.
Now, that exhibit, because the exhibit 8 was not considered in any manner by the learned tribunal, the matter was remanded back. So now, with your presence or in your absence, all that the learned tribunal could have done is heard you on exhibit 8. Others were already heard. Only exhibit 8 was required to be heard. And then then an order was required to be passed. If you come to the order now passed, you will find that at paragraph 12, page 97,
Page 94.
page 94, it
95.
start 95,
Last.
page 95, the last paragraph. Exhibit 8 is taken into consideration. Yes. So he has considered to some extent. And at page 97, paragraph 12 is an entire discussion on exhibit 8. Just now you have stated that you have found nothing wrong in this order because of the only difficulty is you could not be present before the tribunal. Otherwise, no, cross-examination part will come to later on. This exhibit 8 has been considered, is it not? So now, when this court did not grant you leave to face the cross-examination, there was no leave granted for you to face cross-examination again. So that has come at a later point of the order. You will find it para number 15. The only reason the matter was remanded back was non-consideration of exhibit 8. Now exhibit 8 has been considered. We would have understood if you made an argument that exhibit 8 has not been properly considered, but you do not do that. You say I should be allowed to appear. That will only prolong the issue. If exhibit 8 was not considered and now it has been considered, why should we again start up a litigation? Nothing wrong in the order.
No, there's something more. Mr. Vishwa, there's something more. Please come to page 91. Is the earlier rate petition. From the middle, accordingly it appears, para 9. Accordingly, it appears that the petitioner has concealed before the special foreigners registration officer about the ex parte opinion. So and so, we result in erroneous registration of the petitioner on so and so. Therefore, the court is of the considered opinion that the registration is not sustainable, required to be considered in light of subsequent opinion dated so and so. This also takes away your registration. But this can't be an excuse. We cannot, because it was your duty also to keep abreast of your superiors what has happened. 2019. We can't help it.
You are not even challenging that consideration of the exhibit 8, whether it is wrongly done, rightly done, you are saying nothing on that. You know, that was not granted in the earlier writ petition. How can we grant it now? You made a prayer in the earlier writ petition. Whatever was granted was granted. What was not granted is rejected. The only thing we can now consider is whether exhibit 8 has been considered or not, and whether in the manner it has been considered, your presence was necessary.
Okay, yes, you have anything to say? Okay, we'll consider and pass orders. We will consider and pass orders. Just say, Mr. S.C. Biswas, learned counsel for the petitioner, as well as so and so for the respondent. Submissions have been heard, order reserved.
$53. $54.
also heard the learned counsel for the respondents by preparing this writ petition under Article 226 of the Constitution of India. An opinion dated 8/5/2023 passed by the learned member Fairness Tribunal, 4th Nagaon, page 91, has been assailed. Issue notice. Returnable. Give him 20 second, 24. 20, huh? No. 22nd October. Since the respondents are represented, formal steps are dispensed with. Extra copies be served to the learned counsel for the respondents within a period of 3 working days from today. Call for the trial court reports, both by email, usual process. The prayer for bail will be considered on receipt of the trial court reports. However, in the meantime, if the petitioner is apprehended, she shall not be deported without further orders of this court. List on 22nd of October 2023.
Fifty-five.
It's yes. Right. 8:59. Mimi le chiamo nominando titoli di cattiva Mimi. Mimi. Non mai. Duran. Total of Duran.
कितना प्रतिशत बस और करता है अरे where is that certificate? You have any other document except the school certificate?
You will see that. One notice has the name of Rashid. LIC is written.
But your father is Juron Ali.
ADP.
No. Not this. In some of the document here, this notice. That's, yes, the next page says, service report, 76.
Ms. Verma, it's one thing is troubling us. If you come to that page 85, the last order, 14,916. Yes, page 85, the last handwritten order. It says returned unserved as the OP has shifted to other village as reported by inspector by the serial number so and so Omuk PS. Now, if we come to that notice which was sent to her, you will find it at page 80, the report. You'll find the report at page 80. আমি নোটিছত উল্লেখিত গাঁৱলৈ যাওঁ। মুছম্মদ জৰিনা বেগম ৱাইফ অফ সোয়েনসো এলিয়াছ ৰছিদ আলী নামৰ মানুহজনীৰ তেওঁৰ দেউতাক লেট জোৰণ আলীৰ ঘৰত উপস্থিত হৈ মুছম্মদ জৰিনাৰ নোটিছখনৰ কথা প্ৰকাশ কৰাত তেওঁৰ অৰ্থাৎ জোৰাণ আলীয়ে, see it is late জোৰাণ আলী on the top, now জোৰাণ আলী appears. জোৰাণ আলীয়ে নোটিছখন কোনো মতে গ্ৰহণ নকৰো বুলি কয়। তেওঁ এইভাৱে কয় যে ছোৱালী য'ত বিয়া দিয়া হৈছে তেওঁলোকে ভোটদান কৰি আছে, তেওঁৰ নামত কোনো FT কেছ নাই আৰু জামাই জনৰো নাম মিল নোখোৱাৰ বাবে নোটিছখন গ্ৰহণ কৰিব নোৱাৰো। সেয়েহে নোটিছখন সময়মতে জাৰি কৰিব নোৱাৰি। Two things. One, late Juran Ali. Now Juran Ali, they are asking Juran Ali to take it. Could not be at that home, it should have been somewhere at the top. Otherwise, also, he refuses to take it because he says that there is no FT case in the name of my daughter and the husband's name does not match. So I will not take it. But the tribunal records that as per the report of the SP, she has shifted. That was not. And then on the next day, just on the next day, without saying that I'm accepting the report and I'm holding it that the service is deemed now, immediately on the next date, you will find OP is absent as usual. Order is ready. So even before hearing anything, he writes down that order is ready. So on between 14/9/16 and 1/10/16, he prepares the order without completing service, or at least recording that he deems the service to be complete. Would it require examination? On 18/7/2025, you were required to file your WS.
It can't happen because once a proceeding is done, it has to be answered. In that answer, it can say that it's not the same person, but it has to be disposed of. This application at page 110 was filed when? When? February 2025. You see, then the challenge would be, we'll negate the challenge, we'll dismiss the writ petition. Come to page 31. You've already been allowed to contest and file your written statement. Then you don't have a choice. You can take a defense. You can take a defense, but in the writ petition, we are not asking any examination to be done. That is for the tribunal. You move the tribunal. No. But still the reference has to be answered. You move that application. That pair has not been rejected.
It has to be filed. That I am not the person, that is your written statement, I am not the person, you start with that and you prove that you are not the person. So that has to be done by.
We will
before
not
the
take
tribunal.
evidence. We will not record your evidence. That is your defense. You take the defense. You see, whatever has happened, it may be wrong reference, but that's okay. That is for something for the tribunal to decide. And you see, your prayer that you are showing at page 110, that is in an application of Order 9 Rule 13. Correct. So Order 9 Rule 13 cannot be clubbed with any other prayer. It was set aside. There, no other prayer can be considered there. So if you have any genuine ground saying that you still you file an application, it will be what you call in your evidence. You'll have to negate that. But we can't order an inquiry. You see, we'll tell you why. We'll tell you why. Because whether you are a person or not is a matter of evidence. Correct. Now, can the High Court, without appreciating any other matter, say that this examination be done? If you record a satisfaction that you have a prima facie case, that means before adjudication we are applying our mind. Can we do it? This third thing, are you acquainted with the provisions of Order 26, Rule 9 of the CPC, which relates to commission? Those petitions will never be entertained. It can only be answered in the reference. There is a judgment of this court, I won't remember, 2016 or 17. That reference has to be answered. There cannot be a adjudication before the reference is answered. That is not permissible. You see, that is why the burden is on you. Now, by way of a writ petition, can we say that whether he is there or not, the burden would shift on the police? That would make us rewrite the Section 9 of the what do you call Furnace Act. No. It may be wholly incorrect, but it has to be answered. So if you are still aggrieved, we give you the liberty, you can challenge it again. Just a moment, let her complete. You may not disturb, let her complete. Mrs. Ghosh, you see, you are a good person, you see everything good. We are not so good persons, we see everything bad. You see, yesterday we dealt with a matter where the person took a plea that he is not the son of so-and-so. The tribunal rejected that. It came in the writ petition. The writ court made an inquiry, and it was found that he is the son of that man. And the court went to the extent of finding it out from the school records and the metric certificate. Now it was found that in the metric certificate, the petitioner did a manipulation and the name was changed. And based on that, the writ petition was filed. Now, once the matter went against it, then another application was filed where it takes a plea that yes, his father's name is so and so, alias so and so. So when the court, when this admission is made, this court, while disposing of the writ petition, is not harsh on the petitioner. Perhaps the counsel at that time considered. Therefore, it was not harsh. Now, after so many years, review application has now come of order of 2016, telling us that he is not the son of so and so. And there, why we don't know, but a statement was made that his father has an alias of so and so. So that was yesterday. So we have seen everything. People have aliases. You say it is very normal to have an alias. If it's there normal to have an alias, let them decide it. And if you're still aggrieved, you can, while challenging the opinion, you left it open to challenge that also. Once you challenge the opinion and you find that this issue is also against you, even otherwise under section 105, you can still make that challenge of an interlocutory or others. Here also you challenge it.
That option of saying that I am not the person concerned is before the tribunal. No, she had made a the order that we are reading says that there was a prayer for dismissal of the entire proceedings. That cannot be. So square questions will not have round answers.
No, there is one more. In fact, is when my brother told about the square question and the round answer, now another thing has cropped up in my mind. Can you give an undertaking that the police investigation, whatever is made, you'll accept it? No. So how many times this matter can be adjudicated? And you know what happens when we pass an order? You were referring to order 26. Correct. You see this. Give her a CPC. You have it. Oh, okay, thank you. See order 26 rule 10(2). Yes. Report of a commission. Will be evidence. Correct. Now, if I pass an order and this comes against you, it becomes an evidence. You will not be able to come out of it. That's why we asked you a plain question. Will you accept? Can you give an undertaking that you accept the police police report? No. So we can't help. We can't do anything. Our orders cannot be a paper order, giving you further liberty to again challenge that report because it becomes an evidence. Once we direct under the 226, we will not say that the opinion of the police would be subject to further adjudication that can be made. Then we are belittling our own orders. We are making it subservient to a tribunal. So there lies our difficulty. Why we can't, we are not inclined to pass orders because the High Court orders would be now subject to adjudication by the tribunal. We don't want that. Rather, we can give you liberty that once it goes against you, you challenge that also here. Heard Mrs. D. Ghosh, learned counsel for the petitioner, also heard so and so for the respondents. The petitioner, namely so and so, is the person on whom the notice of proceedings of case number. Where is that page
Page
number?
25, Lord.
Hmm?
Page 25,
25
3709 2000.
of case number, page 29, case number so and so was served by the was served on the basis of notice issued by the learned member, foreigners tribunal, Chirang. Full stop. It would suffice to mention that the petitioner is projecting that she is not the intended proceedee for which the learned counsel for the petitioner has referred to various documents. Full stop. It is submitted that though the petitioner has prayed for determining as to whether the petitioner is the intended proceedee or not, the learned tribunal had directed the petitioner to file a written statement, which she did. Stop. However, as the determination as to whether the petitioner is the intended proceedee, no orders were passed, the present writ petition has been filed under Article 226 of the Constitution of India. For sealing the order dated. Where is the 24/6 order?
24/6 of page 25.
It's still the order dated 24/6/2025 passed by the said learned tribunal. By which petition number 89 of 2025 was rejected and dismissed. Next para. Where is that petition? 89?
This is at page 160, Lordship.
160.
160. It is under order 1.
Next para. They said petition number 1. You just said the learned counsel for the petitioner submitted that they said petition number 89 of 2025 was under order 1, was filed under order 1 rule 10 for dismissal of the reference and to drop the proceedings against the petitioner. Which is that order? I'm forgetful that Ms. Verma. That a reference has to be answered. Where is that?
27, Lordship,
Huh?
page 27.
No.
Which one?
The decision of this court where it says that a reference has to be answered. Where is that?
I will, Lordship will give me some time. I'll just give
Okay.
Gunjan, Mr.
Okay.
Sharma has gone out.
It's okay. You can give it by morning. We'll insert that.
Yes, Lordship. मालूम है, मैं बता दूं।
In this, Mrs. Ghosh, in this order 1 rule 10,
Yes, Lordship.
there are several Other sub provisions, you are exactly relying on which one? Order 1 Rule 10.
Specific where did not dismiss it, yeah. There,
Can we say it is to strike out parties?
it made like. Or that. part. Or that.
First of the prayer made in this said petition is as follows. Page 168. Pencil mark. Page 168, 169. Next para, it was suffice to mention that though the said petition number 89 of 2025 was rejected by order dated 24/6/2025, comma, but by order, subsequent order dated 2/7/2025, comma, the petitioner was granted time for filing of the written statement. Next para. The written statement has been filed or not?
No, Not-
The next by the learned counsel for the
Meanwhile-
petitioner has submitted that as per instructions received by her, comma, the written statement has not been filed till now. Next part. The having heard the submissions of the learned counsel for the petitioner as well as the learned standing counsel for the FT matters in the matter. Next, the court is of the considered opinion, considered view that once a reference has been registered, comma, under the provisions of the foreigners within bracket tribunals, bracket post orders from 1964. The reference has to be answered by the foreigners tribunal having jurisdiction. The result of the opinion of the learned tribunal may be in the affirmative or maybe in the negative. But under the scheme of the foreigners within bracket tribunals, bracket was order, comma, 1964, comma, the provisions of order 1 Rule 10 of the CPC has not been made applicable. So the powers of the foreigners tribunal to act as a civil court is circumscribed in order 4 of the said 1964 orders, which is factored below. Order 4. Right. Therefore, comma, the issue as to whether the petitioner is the intended proceeding, comma, if placed in the proceedings of the reference, can only be answered while answering the answered by the learned tribunal while answering the reference. Full stop. Reference once registered cannot be dropped. Full stop. In this regard, we may refer to the decision of this court in the case of
Lordship, there are two I have found out. Lordship's own judgment passed earlier, Lordship. One is Rukia Begum Barbhuya, that is reported in 2023
just
for
write
GLT.
it and give it for the.
I will give it, Lordship. Lordship, this judgment also, Lordship has taken up this aspect here also, Lordship. This is WPC 1428, Lordship, of 2025.
Just write it down, it will be easier for her.
Yes, Lordship, I'll just give. Paper.
This I'll check up. Next. Okay, that will- Accordingly, the court is of the view that the petitioner shall have the petitioner is of the considered opinion that it would be open to the petitioner to take up any defense she desires, including the defense that she is not the intended proceedee. And if the opinion is answered against the petitioner, it would be open to her or to the petitioner to assail the opinion, including the finding of the learned tribunal on the point as to whether the petitioner is the intended proceedee. Next. In view of the limited issue raised by the learned counsel for the petitioner, the other aspects of this case has not been gone into, as it will require determination of actual metrics, for which the present stage is premature, as the petitioner has not filed a written statement before the learned tribunal. Next. It is made clear that none of the observations made in this order shall prejudice either the state or the petitioner, while the reference is being determined. Next, but needless to say that if the petitioner is agreed by any rejection of any plea taken in her defense, it would be open to the petitioner to make challenge this said part of the finding in such manner as the petitioner may be so advised. With the aforesaid observations, this petition stands.
Thank you.
56.
Just now.
Lordship, this case is over, but just one query in my mind is that the actual Jorina Begum, against whom I'm not submitting for my case, but in general, suppose a Jorina Begum, wife of Rustam Ali, then she is safe if, suppose this is against the present petitioner who is before Lordship. Then if it's in her favor, then also the original person against whom if we will take up that plea, because it may not be the same person in our WS, and we will prove our citizenship. but that person will be saved. Yeah, that person will be saved. Jorina Begum, wife of Rustam Ali. I am a wife of Abdul Rashid. He is saved.
It will have to go by the father's name, not by the husband's name, Lordship. No, the notices has the father's name also.
Only because as a lawyer also, I'm just thinking, reason is that then this Jorina Begum, wife of Rustam Ali, who was married at that point of time, and I was the minor at that point of time, will be safe without any proper this thing, because her inquiry is not answered against whom the reference. That is the only query in my mind. Yes, Lordship, but that person is saved.
Lordship, I would just like to make a small submission on what my friend is at, and the name, wife of so-and-so's daughter. In one of our judgments, Lordship, it has been noted here, Lordship. Therefore, Lordship, a very small thing, a notice issued by the Foreigners Tribunal to a proceedee describing him or her as son or daughter of some person, and calling upon him or her to respond to a proceeding where his or her citizenship of India is questioned by the state, cannot be construed as evidence of such relationship. No, her question is Jorina baby wife and ours is on daughter. Like the notice is Lordship, it has gone on both the names.
Where you are calling somebody, as in this case has happened, so and so, late so and so. Can you call a person late so and so? No. So you issue a notice on a person claiming her to be the daughter of late so and so. But you can't come and say that, well, I have served notice and therefore even the dead person will have to come and answer.
My curiosity in her case is that 2016 judgment, ex parte order. She has approached this court only this year in April, Lordship, that Miss case was filed in her review.
No, don't tell us that we have answered it. After that,
Lordship, and why, if she's not one and the same person, if she has evaded the proceeding all through, why now she wants to contest it? It is her prayer that I want to contest this proceeding. I wanted, it is there in the order,
That is
Lordship.
everybody do not know the implications of 105 of the CPC. You've seen that? You take borrow CPC.
Anyways, learning for us also.
You see that 105. Many of the lawyers even present here would not be knowing it. An interlocutory order of, you see, you don't read it, I'll tell you. You see, some orders are challengeable under order 43,
Yes, Lordship.
and those orders which can't be challenged in an interlocutory manner. Those orders can be challenged in the main, when you challenge the main judgment and decree. So it's not that this plea cannot be taken. This order of ours was not necessary. So even if that opinion goes against her, you could have still maintained a writ petition saying that one of the plea taken was not adjudicated. There are 10 points taken in a written statement. You don't have to come running to court for every 10 points you have taken. A constituted challenge can be made.
Yes, please. 56.
In the lordships.
Yes.
Lordship is a very simple case whereby lordship, I have been declared for.
Simple case, we have not got one.
This goes here. Yeah.
I have been declared foreign national by a judgment. The impugned judgment is on page.
No, there's another thing. We said you're not for any other purpose. We are habituated to dealing with complicated matters. So do we adjourn it? Simple matter, we'll have to read and come.
Shall I, your lord? The lordship kindly produce the page number.
Where is your, where is,
Impugned
which
order.
order you are challenging?
I'm challenging the, that is on page number 37, your lordship, connection number 40. Lordship,
Page 37.
yes, your lordship, I would
You
like,
have been declared to be a foreigner. You'll have to wait for some time for bail.
no, not bail, your lordship, I'm free. I'm not
Then?
behind the bar.
Then
Lordship, this was, I have been declared foreign national. I faced the trial under 20 proceeding, your lordship. But then I made one mistake, your lordship, even after furnishing all the documents. The only mistake on my part was that the issuing authorities of these certified copies which I had annexed in the trial court, they were not taken on note, they were not examined, your lordship. Because of that, I have been declared foreign national, your lordship. Let me take the kind lordships to page number 42, your lordship.
It's your burden. Section 9 of it.
Lordship from the may I, your lordship?
yes,
Lordship, the form lordship 38 to 41, your lordship, these are the list of the documents which I have annexed. And some of them I have annexed in the WPC itself, your lordship. But then, your lordship, all these in the observation also, your lordship, all these exhibits could not be examined by the issuing authorities of these documents were not examined, your lordship, because only because of that I have been these documents has not been accepted by the trial court below, and I have been declared foreign national, your lordship. The only prayer before your lordship is that the case may be remanded back. I may be given one opportunity to bring forth the more requisite documents as well as the issuing authorities so that I can prove myself an Indian national, your lordship, as my parents, both of them, your lordship.
and that you say is a simple case. You see, you have made so many people smile.
Yes. Lordship, the petitioner, he was born.
We don't have that much of courage to remand it back without issuing a notice. We lack courage.
For the
Correct.
time being, your lordship, kindly the suspension
No.
of the.
We issue a notice, your prayer for bail shall be considered on receipt of records.
I'm not kind of it.
Same what, no, wait. Your name is Miss
P. Das, your lordship.
P. Das, then counsel for the petitioner. Page 37, so for the respondent. Page 37 is the opinion.
That's the case. Susan.
Yes.
Application is so-and-so, identity case number so-and-so. By declaring the petitioner to be a foreigner of Navigate 71 Street. Notice, return of. Give a date after vacations, extra copies will be included, call for the record, the failure shall be considered on receipt of record. In the meantime, with the petitioner, namely Afia Begum, is apprehended, she shall not be deported out of the country without order of the court. Next, the petitioner shall cause production of a certified copy of the order before the Superintendent of Police order. Which district? Okay, Deputy Commissioner of Police, Border Kamru. List on students.
Oh, 17 August. Lordship, can I pray for the interim, your lordship?
No, interim you are not giving, you are delayed. You come for 23 order, you are challenging now.
Deeply obliged, your lordship.
57.
Yes.
Maybe Lordship. Lordship, the impugned opinion,
Page.
page 64, Lordship.
Heard Mr. Izzat Ahmed. Learned counsel for the petitioner, heard the respondents. Opinion dated 7/5/2025, page 64. Notice 4 weeks. Formal steps dispensed. Extra copies 3 working days. Call for TCR, heard on prayer of interim bail. Prayer is opposed by counsel for respondents. In view of the projection made in the writ petition, we are inclined to grant bail. Petitioner shall appear before SP Border Hubli.
Yes.
List after 4 weeks on receipt of trial court record.
Congress.
Read 58. 58. Item 58. Oh, hit. And 58.
Upgraded item 58.
May please, Your Lordship. The subject matter, my lord, is the declaration of a inclusion of an area in a town committee, my lord. The original notification was issued on 9/1/2014, my lord. Lordship gets it at page 67. It's a notification under section 334 of the Assam Municipal Act, my lord. If your lordship has the act. Of course, my lord, but there are certain parameters, my lord. There are judgments of this honorable court where, my lord, it has been held that the government also has to state what additional facilities you are providing. Because here in this case, my lord, my case has been rejected, the writ petition has been dismissed on the ground that I have not filed my objection within the period of 6 weeks. I am a government of India undertaking. my lord. Because I have to, I am maintaining my industrial township, my lord, and I have to pay the taxes in addition to that. I was not aware of this notification, my lord. Lordship comes to page 67 is the notification under 334(1), my lord. Uh, 67. This is the type copy, my lord. The original lordship finds at page 67D. It is hereby notified for general information that the governor of Assam, in exercise of the powers and conferred on 334(1) of the Assam Municipal Act, intends to constitute a town committee at Namrup, so and so, providing improved amenities. The very object of including it is providing improved amenities, my lord. Within the limits of the boundaries specified below, so and so, expanded with respect to all matters mentioned under section 60 of the Assam Municipal Act. And any objection to the proposal for consideration may be submitted to the undersigned to the Deputy Commissioner within 6 periods from the date of publication of this notification. Now here what is important, my lord, lordship will kindly take up the Act, my lord, section 334(2).
Municipal. Assam municipal.
334(2) says, my lord, the copy of the notification under subsection 1 shall be published in such places as the state government may by general or special order direct, my lord. Then lordship comes to page 69, my lord. This is a communication from the ADC to the circle officer. May I read, my lord? With reference to the subject cited above, I am to forward here a proposal received from the government with notification order from Governor of Assam regarding constitution of the Namrup Town Committee. You are therefore requested to make it convenient for wide publication, reviewing of the notification in the locality, Namrup area, as well as affected area of Naharkutia town locality within 15 days with a consolidated report for onward submission to government. Now, in response to this, my lord, lordship finds my representation in the next page, page 70, my lord. This is my objection to the notification under 334(1), my lord. It clearly refers to the letter of 11(2). In inviting a reference to the letter and the reference received by the undersigned on so-and-so through circle officer, it is to bring to your kind notice that in constituting the proposed so-and-so Namrup Town Committee, a large area portion of land of BVFCL Township as per the record of rights has been included. The details of such land of BVCL is enclosed herewith as Annexure 1. Since the aforesaid land area is exclusively covered by the industrial area of BVFCL, Township and Factory site, and also excluded from the operation of the Assam Panchayat Act, the same should be excluded from the coverage of the Namrup Town Committee under the Assam Municipal Act. Now, this objection has been held by the Honorable Single Judge to have been filed beyond the period of 6 weeks from the notification under 334(1), and on that ground, my lord, my writ petition has been dismissed. By taking the date of notification as 9/1. But I have shown, my lord, from page 69 that at least till 11(2), no wide publicity was given. And by this, it has been circle officer has been directed to give wide publicity. So the ultimately result is the at page 71. And subsection 3, my lord, says that I am required to file my objection within 6 weeks from the date of notification, but date of its publication.
Hmm.
My respectful submission would be, my lord, that if different modes of publication are prescribed, my lord. My lord, 334.
Was this 11/2/2014 even pointed out to the Lord Single Judge? This order does not reflect any reference to that.
It does not. It does not. But it was very much a part of record, and in fact, it was the
No.
admitted position.
No,
Because the respondents of India affidavit has admitted that yes, this was there, my lord. Lordship will kindly turn to,
in your writ petition, did you say anywhere that the date should be counted from 11? Any such assertion?
no. In the writ petition, there is no such assertion. But if your lordship looks at the objection filed, it is with reference to that date.
Just a minute. 63. Yeah. Paragraph 58.
Don't be issue.
Before it petition, it was- There was some interim orders in the writ petition earlier.
Subsequent to the issuance of the notification, of course, there was an inquiry made by the circle officer. That is also part of the record where everything is noted. But the Honorable Single Judge has held that even the circle officer would not have the jurisdiction to conduct an inquiry after the expiry of the 6 weeks and after the notification. my lord. But the notification was under challenge even on merits, my lord.
No, the actual notification saying that now we constitute the town committee, has it been done?
Yes, yes.
When
That was done on 1st of March 2014, page 71.
it's 71 years.
That says that no objection was received. In fact, my lord, even the another corporate body, my lord, the Assam Petrochemicals Limited, they has also filed an objection and a writ petition was filed. That writ petition, of course, in that case, my lord, the objection was filed within 6 weeks, and that was interfered with by the honorable court, this honorable court. This particular notification. Because here, my lord, what the notification says that. But I may point out, my lord, in that particular case, it was within 6 weeks. The objection was within 6 weeks. WPC 1694 of 2015, my lord, ordered it at 16/7. Your Lordship reads the final notification at 71, whereas 42 days from the date of publication of the notification under so and so, dated 9/1 under subsection 1, have expired and no objection pursuant thereto have been received. So 334, four mandates that upon receipt of the objection, you are required to consider it. This consideration was not done. Copy of the gadget of which notification, madam? It is there, madam, at page 71D, madam. Not the gadget, madam, but the notification itself. Gadget notification is not part of the report. Mhm. Again, and again. Hmm?
That is 1st of March 2014. Which are the dark numbers or which are the portion which affects you?
51 darks, my lord. The details are at page 86, I think. Just point out. Because subsequently a hearing was held, my lord. There was a report prepared, my lord. All the darks are there. Page 111.
Yes.
Page 111. Name of babies. This will have tally. Say it as well.
Yes, who's appearing to the respondents? What do you say?
We have to say on the prayer for interim relief.
Secretary to Government of Assam Urban Development Department.
Election.
They have their own council, urban development. Earlier, we are not passing an earlier order, we are passing an earlier today. Or in the earlier round of litigation. Can you find out?
SC urban development. SC urban development. You are there?
Eight, my lord, eight at this moment, my lord, eight may, because at that point in time, there was an impending election that is why it was made a party, since it was a party in the writ petition, we have eight, my lord. Against eight, we don't have any grievance right now.
See if the urban development standing council comes. Is that
He might, because, my lord, the material instructions will also be there, my lord.
Item 59.
May I please, your lordship? For a matter relating to acquisition and compensation. And my matter is that in the year 1962, during the Chinese aggression, some army personnel were there making camp at the Rongia three villages, Nokul, Sahan and Septik. Since then, they have been occupying many plots of land, including this plot of land in this matter. And initially it was under the Assam Land Acquisition and Acquisition Act. And thereafter in the year 2005, some acquisition process were there. And in the year 2013, they were going to make some payment. But at that time, my name was not there, for which I made an application before the SDO Civil, because he is the concerned authority, which is at page 39, my lord. Annexure 3 of the writ petition. Page 39 of this writ appeal. This application was made instead of, because the land was originally in my grandmother's name. But instead of my grandmother's, the private respondent's name, initially another school was there, 32 Nong Buniyadi Vidyalaya. That was there. Subsequently, the present respondent, private respondent, which is a high school, both schools were merged. Thereafter, my lord, page 40, notice was issued to me as well as that school regarding hearing, page 40, my lord. Thereafter, my lord, nothing was done, my lord.
Tell us what is wrong with the order of the learned single.
My lord.
What is wrong?
First of all, my lord, the learned single bench focused only on the date of award as well as my application.
prior to that, the school, the name of the land was in name of Secretary of School Board. Then it was recorded in the name of Nakul Bunyadi School way back in 1971.
That is correct, my lord. But the thing is that the land was since 1964 under the occupation of the Defense Ministry.
But mutated in 71.
So
You
the
did not- there
question
is no
comes, my
challenge
lord,
to that.
my lord,
Prior to that, it was in the name of Secretary of the School Board.
no, my lord. The initial mutation, my lord.
You have chosen a wrong forum to come here.
No, my lord. Actually, I made the writ petition only against the conduct of the circle officer. Instead of hearing conduct a hearing, what he had done is
He's
my
done right.
lord,
He has done correctly.
my lord, kindly come to page
You
number.
see this, that's why my brother is asking you a question. You see this, the mutation was done in 1971. That's my esteemed brother has pointed out. Against that, what did you do? You have Transfer of Property Act with you?
Right now, no, my
No,
lord.
no, not now. You give him a Transfer of Property Act. See section 3. Notice. We'll give you the book.
Section 3, my lord. Interpretation clause.
Yes. Person is said to have notice. Please read it.
A person to said to have notice of a fact when he actually knows the fact, or when but for willful abstention from the inquiry
Abstention.
or search which he ought to be have made, or gross negligence he would have been known it. But my notice is, my lord, in the year 2013 December.
That's what we say. You see, are you aware of the land acquisition proceedings, how it is taken up?
Yes, my
See
lord.
from section 9 onwards, 9, 10, 11, 12.
My lord.
Is it your case that no notice was published for the land acquisition? Is it your case that the land acquisition notice was never published?
But notice were published,
Notice was published.
my lord.
So you again come back to that Transfer of Property Act, section 5(3) interpretation. You must have notice. So once a newspaper notice is given, you are deemed to have notice. Now, second is that when the land survey was made, preliminary notification was also issued.
My lord, let me give the gist of the time frame, my lord.
Don't tell us everything. We are asking a very pointed question.
At that time, I did not know about the
You did
notification,
not
my lord.
know. So section 4 notification came, you did not know the section 10 notification by which the position were taken over, you don't know. The land acquisition compensation under section 10 that you don't know.
No, when the final notification was regarding the payment and giving the submission of the documents, then only I came
Payments
to.
are made under section 10 before
My
taking
lord.
possession.
Yes, power to require and enforce the making of a statement.
Therefore, you were never in possession.
No, since 64, the possession is under the Defense Ministry, my lord.
Correct. But you see, now please tell me, we have a small plot of space beyond this building.
My lord.
It's a High Court property. Do you expect us to go there and sleep there and keep the possession like this? It is not there.
No, no.
Correct.
Yes.
So people don't have constructive, the physical possession, but they still have constructive possession of the land. A owner cannot say that he is not aware of his land just because it is under the defense. If it is under defense and not acquired, then it is covered by the Land Acquisition and Requisition Act. and you get paid rent for it.
That is correct.
So can you think of a landlord not knowing what rent he is receiving and who is having that property? So you are at a wrong forum. You are rightly dismissed.
But then also, my lord, one section is in my favor. If we take the time frame also
You
as
see, you are wasting our time. Second thing is, after the order of the circle officer is passed, where do you challenge the orders of mutation?
no order is passed, my lord. That is the
Correct.
problem.
Even if it is not passed, where would you challenge it? It will be before the, under 147, it will be before the court of the deputy commissioner. And thereafter it will go to the board of revenue.
My lord.
And you won't ask, your prayer in the writ petition is what? Read your prayer in the writ petition. What is that prayer? Read it loudly, refresh our
For-
memory.
Remanding the,
No,
as well
refresh our memory. Please read that.
it is therefore paid before lordship to admit the present writ petition, call for the record, issue notice upon the respondent directing so cause as to why the land measuring this and that at Dag number this and that shall not be restored in the name of the petitioner
Restoration of mutation.
followed by the subsequent release.
Restoration of mutation. You want the High Court to do it.
No, my lord. I was to direct the circle officer to take the.
Without giving a
conduct the
finding.
Hearing,
Without giving a finding.
but the circle
want-
officer has not done anything.
I understand. You expect us to give a finding and then send it back, or you want us to send the matter there without giving a finding?
But the under Land Acquisition Act, the circle officer as well as the SDO civil is duty bound to do whether the who get the compensation, who is the owner. That is one part.
That is a determination
Mutation
under
cannot
section-
confer
That
any.
is a determination under section 12. Is it not? I forgot. This is the land acquisition act.
If we, there are two parts, my lord. One is within 2 years, if it is not done, that since the
No, but
publication.
what is the provision? I am forgetting. I am, section 12. Determination of compensation.
Award 11 is inquiry, and my lord 12 is award of collector when to be final, yes.
12.
Yes,
So I have not.
and I am also relaying this
Correct.
section because after completion of the award, they have to give notice.
Just,
And since publication till award, if this whole thing is not within 2 years, the whole matters is, my lord, become infructuous. That is also under section,
notice to whom?
person interested,
Notice to whom?
person interested.
Person interested would be who? Who would be the person interested?
First of all, the circle officer obviously sees that name in the Jamabandi and the pattadars. That is
Correct.
correct, my lord.
Correct.
But
So
there,
your name is not mutated.
my lord. No, earlier, my name was there, my lord.
No, you see, I am a simple man with complicated thinking. When I pass the governor's house, I always think this should be my property. Every time I cross the governor's house, I think that no, this should be my property. I don't have the capability, I don't have the ability, but this thought is always there that that should be my property. But you see, the governor a few days back made a construction. He did not ask me. Home Minister came, inaugurated it. No one asked me. I have an interest. Since my childhood, this governor's house should be mine.
But the thing is that your grandmother was the recorded pattadar. That is the problem, my lord. And what is important,
Under land and revenue regulation, what is the time within which you should apply for mutation?
restoration or mutation, my lord? Because
Mutation,
mine is restoration
mutation
within 6 months, I think.
within 6 months.
But the thing is that they are claiming their mutation. They could not get any single document to show
That
that
is a
they had
revenue
been.
appeal, matter of revenue appeal. It goes under 150, 147. 147 to the revenue, and then it comes to the Board of Revenue.
But the, my lord, Land Acquisition Act also, my lord,
This does not cover normal mutation.
my lord, in that case, may I, my lord, just place one order of the initial order of this honorable court passed in the writ petition, saying that the payment should not be made without confirming who is the owner. And as per my understanding, my lord, the Land Acquisition Act also confers the duty upon the authority to see if any objections are there, to verify whether any claim is there or not.
Where in the repetition is from the meeting.
My lord. With subsequent relief, my lord. Subsequent relief means compensation or anything else.
Initial relief of restoring your mutation. So subsequently,
That is correct.
was how we can restore the mutation in the repetition. That's what.
No, my
This is how we can.
My lord, my main prayer in this petition,
Make the DD. Just read it, we will read along with. Where is it?
then my lord, may I just point out one thing, the non-action of the authority. That is why actually first
For
my.
compensation, suit for compensation, you will be more happier than in a writ court. If you are deprived of the property, not mutation done, the cycle officer did not act, they don't have defense, you file a suit for recovery. Suit is not bad. Prosecution would be bad under 197 unless a sanction is given. But civil suit is not bad for damages.
My lord, in that case, my lord, the last impugned order, last paragraph, what I understand, my lord, the only thing in this order that the notification was published
See,
in the
I
year.
have a simple solution. If you want to catch the nose, catch it directly. Don't do roundabout and then try to catch it from here. It will take you a lot of time.
No,
You
my-
can't catch the nose by in a different way. You have a dispute with your other members of the family, settle it outside. Go to a civil court. Go to the Board of Revenue, go to that. Writ petition would not lie. This is a disputed question of fact.
My lord, what my humble prayer is that in the writ
No, can I,
petition,
you see, that's why we are time and again asking you. Now, can a writ petition be filed just by saying that, okay, please have that land measured, have this mutation done? This, what you call, these secretaries, they have not done this work.
but my actual intention was against the conduct of the authority, my lord.
Well,
Because they themselves given the certificate that there is no objection. That is the problem. One problem. My lord, may kindly come to
That is
Annexure
not-
8.
That is not the case projected, that is not the prayer made.
Case is projected that. My lord, prayer that is, I understand that I should have taken the.
Revive the
No,
writ
no, we
petition,
don't-
file an amendment, amend the prayer, then come back. This is a writ petition. Article 226, we go by whatever is there on the file.
My lord.
We trust everything here. We even trust the prayer made is done with due application of money. So if the prayer is wrong, the reply will not be correct. We trust everything, the competency in draft.
You see, there's only one way out. You will have to make a submission that this writ petition was clumsily drafted.
The prayer portion, I, my lord, admit that.
No, we don't
some-
say that. You see, what my esteemed brother has said, we have complete faith on what you did was bona fide. Now, unless you make a submission that yes, I drafted it clumsily, writ petition was not rightly drafted, Then we may hear another thing.
Rare portion I also accept, my lord, some
It is,
better options.
you are
like-
the holder of the brief. You are the holder of the brief. You can't make claim that this is what what is the intention.
Because my whole, my lord, projection in this writ petition,
You have
Even
not
in the
ready this-
interim prayer, you were trying to point out to us, what was the submission made before the court? That you are in possession of the land, you are the owners of the land, you are everything in the land. Land has been acquired, compensation has not been paid, and therefore an interim order should be there. An interim order was there.
no.
Yes, please read the first paragraph. What is no matter? Claiming to be the legal heirs of so and so who was the original owner of the land.
What statement is
The
in my-
present petition has been filed inter alia contending that although possession of the land was taken over by the authorities many years back, yet neither any compensation has been paid to the landowners nor possession has been restored to them till date.
That is correct.
This was a court which trusted your submissions without looking at the prayers.
And that is correct, my lord.
So that prayer was not even looked into, and only on the basis of submissions, this interim was passed.
No, because
All
my lord,
throughout,
I think the prayer is
Now cost. Now more you speak, the more cost will go.
my lord, I am only on the,
Start with 25,000.
I'm really sorry, my lord, but I am only on the land acquisition, like nothing else, my lord.
It's your
I'm-
choice. We are giving you a choice. It will be a well considered decision. You want to argue, you argue. But cost will be 25 now. 5 minutes more, it will be 50,000. And beyond that, we will also say that you have committed fraud by making a wrong submission before the learned single judge while obtaining an interim order.
That my lord, what I state, my lord, that is absolutely true.
Otherwise you make a statement here, we are recording it, there's a live streaming going on. You give a statement that this observation of the single judge was not as per your submissions.
Well, impugned order.
Oh, you're sorry. We can't give you more time, we are not interested.
I
You're
leave-
making a mockery of the legal system.
I leave to you, my lord.
But Mr.
DK
DK Nath, learned counsel for the petitioner. Oh, sorry, appellant, also had. Yes, I am sorry, we did not hear you.
Right. Apart from all, my lord, the appellant petitioner was also a teacher of the high school. And he retired recently, my lord, in that high school. my lord. Apart from all,
Okay, yes, anything more? No, 7 this school, okay. Counsel for the appellants, also heard, also, Mr. B. Goswami, the additional advocate general, assisted by Mr. P. Kakoti, learned counsel for respondent numbers 4, 5, and 6. Mr. B. Decker, learned counsel for respondent number 7. Mr. P. Decker, sorry. 7. Ms. A. Gahan, learned counsel for respondent number 1, 2, and 3. You are for the CCC, as a CCC for respondent number 1, 2, and 3. Next paragraph. By filing this intra-court appeal, the appellants have assailed the impugned judgment and order dated 5/6/2025 passed by this court in by the learned single judge of this court in WPC 202 of 2021. Next paragraph. The bill made in the writ petition is as follows. This is Page 129. Next. The the case of the appellants, as projected in this intercourt appeal, is that their predecessor in interest, namely, Mahamaya Devi, during her lifetime, was the absolute owner and possessor of 2 plots of land of various descriptions. Yes, where is the schedule to this writ petition for land? In this appeal, you have given a schedule.
My lord, in the page number 3, para 1, the statements is there, Dag number.
No, no, here you say that, you see, we are asking you because you have written here. Within bracket, more particular described in schedule. Therefore, we are asking you whether there is a schedule.
Sorry, my lord, no, not.
No. Which is described in paragraph A1 of the writ petition. Sorry, of this memo appeal. It is projected that the said plot of land was in occupation of the armed forces. The entire land? No,
My lord,
the entire land was in possession of defense.
actually 3 villages, at least 50, well, a huge plot of land. 50% of the 3 villages. I have also went there. The camps are still there, my lord.
No,
And
please,
this-
your personal knowledge, don't tell us. From the paragraph 1, you have 1 bigha katha and then second plot is 3 katha 7 lecha
no, my lord, 3 katha 7 lesa is under the occupation of the,
of the defense.
yes,
Of the defense.
yes.
It is submitted that out of the land described in paragraph A1 of the memo of appeal, from a land measuring 3 katha 7 lechas was under the occupation of the armed forces. Full stop. In course of time, land acquisition proceedings was drawn up for acquiring the said plot of land measuring 3 katha 7 lechas.
I'm sorry, my lord, 4 katha 15 lecha. Because there
Where
are
do
2
you find
dags.
that land? Please tell us. That's why we are asking you.
No, my lord. In dag number 2 dags, 1 dag 1 bigha 1 katha, another is 3 katha 7 lecha. Out of this total land, 4 katha 15 lecha was under the occupation of the.
Where is the statement? Please tell us the statement.
The prayer portion, it is, my lord, reflected in of the page 30, my lord, of the writ
Page?
petition. Page 30 of the writ petition.
30.
Yes. Prayer portion of the writ petition, my lord. 4 katha 15 lecha at dag number 130.
Fact of, because if you say that on being asked, the learned counsel for the petitioner has submitted that out of the said 2 plot of land, which is described in paragraph A1 of the memo of appeal, a total land measuring 4 katha 15 lecha was under the occupation of the armed forces. And consequently, land acquisition proceedings was drawn up for acquiring of the said land measuring 4 katha 15 lechas Right, LA case number 8 of 2005, comma, LA case number 9 of 2005 and LA case number 10 of 2005. The learned counsel for the appellants has submitted that the compensation amount has not been paid to the concerned persons till 2014. And no notice of the proceedings was served on the petitioner, on the appellants. Now, the school is in which land? Why does the school come in here in your appeal? Why you
Because,
have implicated the school? Sorry, why you have referred to school?
my lord, initially the school name was School Board Secretary. That
No,
was
whatever be, what is, you see, you are challenging the land acquisition. Why you have mentioned about the school and the land of the school? Why?
because the notice has been issued to the school and the mutation is done in the year 1971 in the name of school. That is, I come only after filing of this writ petition, my lord.
This 4 kattha land was mutated in the name of the school.
My lord, in the year 1971.
It is also submitted that in the meanwhile, in the year 1971, the said 2 bigha 15 lacha land was mutated in the name of, yes, what name? What is the name in which the land was mutated? Pardon me? Siddhinath Vidya Mandir High School.
No, my lord. Initially, the land is still in the name of 32 Nong Nakul Buniadi Vidyalaya. Both schools were amalgamated. But I think still now the name is under in the name of that
No,
school.
no, just tell me one answer. What is the name in which the land was mutated?
32 Nong Buniadi Vidyalaya.
Okay. Take it off. 32 number.
Nakul,
NIMNA Nimna Bunyadi, BUNI YADI, Bunyadi Vidyalaya.
Yes, page 5, my lord. And this is information has been,
I don't know, there's something wrong. You come to paragraph 6, in the paragraph 6, you said that another plot of land, 4 bigha 1 kattha has been mutated in the name of so and so. Is this land also acquired?
paragraph 6, my lord. Siddhinath, my lord, there are 2 schools. One is,
I am not, you see, history is something I am not interested.
my lord.
Just I am asking you a point-pointed question. You are challenging the land acquisition. Is this 4 bigha 1 kattha 7 lacha land part of the acquired land? No.
No, my lord.
Then why you are making it clumsy? You see,
No, my lord. That is part of the, but that is another land that is also acquired by the army, but that is belongs to the higher school. As because both schools are club, these kinds of problems are occurring, my lord. That is why I made the statement, my lord.
no, no. You speak to. You see, in a lighter note, I am saying, I ask you a question, not you, I ask a question, what is his name? What is your name? He will say that my father name is so-and-so, my mother name is so-and-so. Then you asking me, I'm immediately asking your name. He says, no, first my father and mother has to be married. Then I will be born. Then I will get a name and I'll tell you. What happened to other land is an history. Why we not want to know that? Full stop. It is the full stop. They said school has been renamed as 32 number Nimna Bunyadi Vidyalaya. Full stop. It is also projected that they said land was mutated in the name of the school, which was hitherto not known to the appellants.
No, no, that was for the record for you.
One, Ajay, you forget the story.
This is reflected.
You forget the story.
And
You forget the,
here in the.
no, no,
In judgment.
we forget the entire story. We just now say
Yes,
that
is there.
that part of the land was acquired, the land measuring 4 kata, 15 acres was acquired. So the grievance of the petitioner is, petitioners, sorry, appellants, is that they had on coming to know about the land acquisition proceedings, you have applied for mutation in your name,
No, my lord.
then
Because soon after I knew, I made the application for, before the SDO to, for under Land Acquisition Act for compensation.
okay.
As well as the,
The
obviously the restoration. my lord.
application was made before the collector, Kamrup, for appropriation of the land acquisition compensation to them, being the legal heirs of late Mahamaya Devi.
And for compensation.
So that's what it says, appropriation of compensation.
Page 39 my lord, is the application.
To stop. The said application is stated to have been filed on 24/6/2018. To stop. The said application was made over to Additional Deputy Commissioner, Kamrup, for determination. To stop. It is projected, it is submitted by the Learned Counsel for the petitioner that at the end of November 2020, when the petitioners, when the appellants went to the concerned authorities to inquire about the matter, they were informed that that the circle officer, by a letter dated 21/2/2020, had reported that there was no objection if the compensation was awarded for the school. Accordingly, the aggrieved appellants had filed a writ petition before this court. Next paragraph. The contention of the appellants before the learned single judge was that that their application was not put up for hearing. And that though a report was called for at an early date, the report submitted by the circle officer, Rangia Revenue Circle, had indicated that the original owner of the concerned land was the predecessor of the appellants. and that there was no record of transfer of land to the private respondents. Where is that finding? Where is that report?
Page 48, my lord. I am on this part, my lord. Sorry. Page 48.
The learned counsel for the petitioner has submitted that disregarding the said report of the circle officer, comma, the authorities have taken steps for release of the compensation amount to the respondent number 7 school, correct?
Madam. Well, that decision was not taken actually. That final decision was not taken to issue in their name. It is just
You
forwarded.
have not said that. He has given a report and you said that it was not considered. The learned single judge, upon consideration of the projections made by the petitioner and the respondent, had taken notice of the contentions advanced by both sides. Specifically, the contention of the petitioners that the two lands were under possession of the two different schools which are adjacent to each other. And therefore, the petitioners have stated that perhaps by bona fide mistake, land of the petitioner has been mutated in the name of the school. Full stop. The learned single judge also considered the land revenue records produced by the learned additional advocate general, showing the names of the registered patrādārs. And this court and the learned single judge arrived at a finding that the said document goes to show that the land were recorded in the name of Nakul Bunyadi School way back on 11/1/1971. And that the records also reveal that prior to the said correction of land revenue records, the land was recorded in the name of the secretary of the school board. Full stop. Next, accordingly, on arriving at a finding that the land were recorded in the name of the school way back in the year 1971, and the land acquisition proceedings was initiated way back in the year 2005, comma, the award was passed in the land acquisition case being LA case number 10 of 2025, 2005/1062 on 18/9/2013, comma, which was approved by the state in the Revenue and Disaster Department, Disaster Management within bracket LR, bracket post department on 21/9/2013. Stop. Resultantly, comma, as the prayer in this writ petition was for restoration of the name of the predecessor and interest on record, comma, the learned single judge expressed an opinion that the prayer made in the writ petition cannot be entertained as the petitioners had, as the appellants had failed to avail remedy under the Land Acquisition Act from 1894. Next paragraph. It is well settled law that once a land acquisition notification is issued, comma, transfer of the land is not permissible. Under that circumstances, comma, the order for restoration of the name of the predecessor in interest of the petitioners could not have been allowed. Therefore, comma, if the petitioners, if the appellants had any grievance of the regarding the manner in which the land was acquired, comma, which so permitted by law, comma, the remedy available to the appellants would be elsewhere as prescribed under the Assam Land and Revenue Regulation, comma, 1891, 1898, 1891, and revenue. 1881, I forgot.
81, I think 81.
1881. Oh, I forgot. It's I don't know. Assam Land and Revenue Regulation. Stop. And if the orders passed in the proceedings, comma, the further appellate remedy is also available before the competent authority. Next. The learned counsel for the petitioner submitted that it was the erroneous mutation made in the name of the school for which he had approached the land acquisition authorities, but no decision was taken. So, in this regard, we find that the orders passed by the land revenue, by the land acquisition authorities, there any orders on the representation of the appellants is not a subject matter of challenge before this state court, before the learned single judge in the writ proceedings, which is evident from the nature of prayer made by the appellants in the writ petition, comma, which is extracted herein above. Next, this was circumstances, comma. The court does not find any merit in the challenge made against the impugned judgment and order dated 5/6/2025 passed by the learned single judge in WPC 202 of 2021. Accordingly, comma, this intercourt appeal stands dismissed at the admission stage without issuance or notice on the respondents.
My lord, may I pray for the liberty?
So we have said it's not the prayer. For that, you don't need the liberty. We have not entertained your prayer and dismissed it.
Otherwise,
We have said that there's not the prayer made. So always you'll have to challenge it.
But Assam Land and Revenue Regulation, 1886.
86, right, yeah, 86, yes. Sorry. Too much of foreigners matters. We're forgetting the land revenue.
okay.
So there's Mr. Deka. Other matters, we won't have time again. I'm sorry, few upgradations we ordered, but we hardly would have time. Okay, give it discharge. Give it by, in the last matter, give it was by Mr. Reka. In the last case, Mr. Goswami.
Private
last matter,
respondent, respondent number 7.
Respondent number 7, so
Yes.
Mr. Deka.
P Deca.
So in that
You
last
are-
matter, we dictated the order. Who is 7? Also, Kevin, you will have to tell us to discharge it. Okay. Mr. P. Deca. Okay. Yes. Yes, Mr. Deca.
I think the GA will appear for the state, my lord.
Even before the single judge.
Even before the single judge. my lord.
Timing item 58.
Mr. Nath. In this 58, you will be appearing? No.
58.
Do you have in your record the gazette notification? The notification of first of March.
Gazette খন আছে নেকি? পেজটো আপোনাৰ
The first notification.
First of March 71 day.
Page 67. First of March and 9th of March.
1st of March and 9th of January is the first notification and 1st of March is page 71 day. Sixty-seven is the type copy.
Mr. Nayak, since you are appearing, we'll issue notice and in the meantime, that implementation of the notification shall be excluded only in respect of the land covered by this number by the appellant. Brahmaputra fertilizer. Yes, but we are staying it so that the amount cannot be realized. No.
This is not, if I am not aware, what will be the implication of staying the?
No,
Okay.
you see, if even if there is a, you see, when a land is given to a municipality, it will only lead to higher revenue.
First, not if we consider the maintainability of this petition or whether this company law has any authority or purpose not for challenging a notification or
This land is of whom?
designated a particular area lot whether it's town.
No,
committee.
who is the owner of that
Challenging
land?
notification for designation. I am challenging my inclusion in that area.
Who is the owner of that land? In which respect of which he is challenging?
Not
He is the owner.
51 numbers of that lot belong to the I mean,
So therefore, he has a right. A company can make a challenge.
but the dismissal was not on the ground of maintainability. It was dismissed because it was submitted after expiry of the stipulated.
No, there we have our reservations. We have examined the records, we have our reservations. So therefore, your notification is there.
Yes.
Only the inclusion of their DAG will be stayed for the time being. We'll take it up after this puja vacations on whichever date you say. Okay, Mr. Deka.
Hello.
We have deliberated. In fact, we have realized that during the writ petition, no stay was operating.
stay.
So we say that if you are agreed by any action taken, you may file
Right.
an interlocutory application.
In fact, my lord, notices have been issued. I have not brought in on a record. My lord. Demand notices have come
Under 107.
under 107. They have,
File an interlocutory
we'll
application.
file it out.
Heard. Mr. N. Degal, learned counsel for the appellant, as well as Ms. For CGC who was there. Oh, you are there, Ms. A. Gayant, and CGC for respond number 1. And Mr. P. Nayak, learned additional advocate general. I'm appearing for the state respondents. Assisted by Mr. D. Nath, learned senior government advocate, appearing for respondent numbers 2 to 7,
2 to 7.
right?
2 to 7. 2 to 7.
As well as Mr. 2 to 7 and 9 also, I think, no.
9, I think notice will have to go, my lord, town committee.
Huh? Town committee have their own council law. Okay. And Mr. R. Dubey, Leonard, planning council for respond number 8. Next paragraph. By filing this intra-court appeal, the appellant has assailed the order dated 5/6/2025 passed by the Honorable Single Judge in connection with WPC 659 of 2015, thereby dismissing the writ petition. Also, the learned counsel for the appellant has submitted that the ground on which the writ petition was dismissed could not have been attracted in the, under the facts and circumstances of this case. It should. The if it is admitted for hearing by issuing rule returnable forthwith without requiring any. Returnable, give a returnable because it issue notice on 9. Returnable on. Mr. Nayak, fix a date. When do you want? Give a date.
Madam?
Mr. Deka,
Yes, madam.
please consult with Mr. Nayak, have a date.
14, 15, any date.
17 or 17/10/2025. Requisite extra copies of the of this memo of appeal be provided to the learned CGC, is CGC and the learned state council within 2 days. Next. Issue notice on respond number 9, which is also made returnable on 17/10/2025. So the appellant shall take step within 2 days for service of notice on the 2 working days for service of notice on the respond number 9 by right to post with AD. As well as by Dusty,
If possible, yes, ma'am.
as well as by Dusty,
No.
and on service and affidavit of service shall be filed prior to the next date of its date. The sixth process to the registry on service and affidavit of service. Next paragraph, at this stage, the learned counsel for the petition has submitted that in the meanwhile, as per his instructions, demand for revenue, the payment of municipal, municipal.
Tax.
Town committee. It's a town committee.
Town committee.
Town committee tax has been served on the appellants. If that is so, the appellants are at liberty, appellant is at liberty to file an interlocutory application for my so desired. Next, list on.
Blood.
May please look, my lord, item number 30 may be fixed, my lord. It was upgraded much.
Tell the courtmaster, we'll have to make some adjustment. There are cases piling up. It's taking too much of time for the matters. Whoever asked for upgradation, those cases.
Item number 70, my lord, second. Payment was.
Please tell him. Yes. Oh, yes.
Then have been given by the DCB and it is now financial consolidation law. They will
Okay, that is item number
17.
Huh?
17.
17. Okay. Item 17. See, both sides are represented. Mr. D. Nath, the senior government advocate, has submitted that pursuant to the orders of the court, the Undersecretary to the government of the Home A within bracket close department of government of Assam, to a communication made by the Undersecretary to the government of Assam, Home and Political Department, has communicated the sanction of the proposal for a sum of rupees 2 lakh for payment of interim compensation to the petitioner. The learned senior government advocate has submitted that he expects the total formalities and approval of the competent authorities in the matter to be made available within a week from today. In a period of 10 days from today. The said communication dated 5/9/2025 along with the enclosures thereto are retained on record on the prayer made by learned and the senior government advocate from the matters and on today, list on, give a date after 10 days, late 14 days, 2 weeks. We make it 24 because last day will be too hectic. 24/9. Next. It would be permissible to the learned senior government advocate to send a download copy of the concerned authority. If so desired, list on.
I'm so obliged now.
Item 68 Monday didi bo. আইটেম 68 মানডে দিয়ক না দে আর দিন দুদিন পর আহি আছে মেনশন কৰি আনিছিল লাষ্টতে মেনশন কৰি লাষ্টতে আনিব নাই সেইটো আমরা আনি দিছিলি উঠিব আর্জেন্সি বলে বলে হব ভোগী সব খবর দিতে সব করে দিও ভোগী দিতে মুরগি দিতে কি হবো হাতে বেশি দাম তুমি ফসলি দিতে এই করে কাজ করে দিয়েছি
মেডামৰ কথা কি কম মানে প্ৰশংসা কৰি উপচাই দিব
গৈছো এতিয়া চাওক কি
এই দেখাই
লগত কথা নাই স্যার হ্যাঁ 58 to নহয় 1710 24 9